The special counsel sat there and admitted it under oath. He charged Donald Trump with conspiracy, knowing full well that a conspiracy requires more than one person. He named the co-conspirators in the indictment, and then he left every single one of them unindicted. How often has he done that before? He couldn't even give a straight answer, just shrugged and said it's not uncommon. Watch what happens when the questioning turns to January 6th itself. Members of Congress talking about decertifying electors over breakfast. Not a crime. Urging colleagues to join them? Not a crime. Trump saying he won the election even if he said it falsely? Protected. The only thing supposedly illegal was using knowing false statements to target the certification process. And yet the theory stretches from December all the way through the counting of the votes. This is the same case the Supreme Court just dropped a nuclear ruling on. The prosecutor's own words are now hanging out there for everyone to see. Please subscribe our channel for further exclusive content.
Smith, isn't it true that for a federal criminal conspiracy charge, it requires more than one individual? In other words, you're making a contractual agreement of some kind with somebody other than yourself, right?
That is correct. There has to be an agreement.
And so when you made the determination to charge President Trump with conspiracy, you surely knew that you had somebody else that he must have agreed upon somewhere to engage in this act that generated the conspiracy, right?
That's correct. We alleged specific individuals in the indictment as co-conspirators.
And so you knew who you were going to do who you were going to charge when you pursued the indictment. You knew who the agreeing parties were, but you chose to list them as co-conspirators, but you didn't indict them. How often have you done that in the past?
In the past, I have had number of cases where I have charged some members of a conspiracy and not charged others.
One member of the conspiracy. How many times have you done that? Charged one member of the conspiracy and let everybody else off the hook?
I'm sure that's happened. That is not an.
You don't remember doing that?
That is not an uncommon thing to do in an investigation. In my view.
So okay, I dispute that, but we're going to leave that as it may. But let's just get to this: if a member of Congress moves to decertify a state's electors, that would not be a crime, would it?
When you say to decertify,
you make a motion to decertify on that January 6th. That way, every 4 years. That's not a crime, right?
Correct.
And if another elected official urged someone to join them in that decertification, that's not a crime either, right?
As you stated, it's not.
Several members of Congress get together over breakfast. They say, this is the normal path. We watched it because we saw the Democrats do it for every Republican president. So we're not sure how to do it. We've never done it before. That's not a crime to sit down at breakfast to talk about that or any other time together to talk about decertification, is it?
No, it's not a crime to talk about that over breakfast.
In your deposition, you talked about, you made the argument that an elected official who's been deemed to have lost could not knowingly make false statements about election fraud to target a lawful government operation. Isn't that true? That's what you said in your deposition. Page 27.
I believe it's a lawful government function.
Yeah, I'm sorry. Yeah, lawful government function. That's what you said. You remember saying that?
I said lawful government function. Could you read back what you said again? I'm sorry.
Yeah. An elected official has been deemed to have lost could not knowingly make false statements about election fraud to target a lawful government function. You said that would be illegal. Remember that page? Do you want me to actually read this back? Surely you remember that position.
I'm not denying it, and I apologize. I'm just trying to listen to you closely.
Okay, let's just go right from this. You said as we said in the indictment, he was free to say that he thought he won the election, right?
That is correct.
He was even free to say falsely that he won the election, correct?
That's correct.
What you said is he was not free to do was violate federal law and use knowingly false statements about election fraud to target a lawful government function.
That is correct.
Yeah, and for you, that lawful government function is the certification process, I suppose, on January 6th.
Well, it's a slightly broader than that. It's the collecting, counting, and certifying of the votes. Our view of the evidence is that begins from the point of time that the electors are certified through the counting of the votes. So that would be
so the entire certification process from the state to the feds.
My recollection, as it's pled in the indictment, as I sit here, I don't have it in front of me, but I believe it's from December 14th. I think that was the day through the voting.
Okay, so you can't recall, but for you, it's from the certification moving forward to the actual ratification of the certification process on inaugural day.
My recollection, that's what we pled in the indictment, yes.
Okay, so you've managed to filibuster us right out of this thing, but your beef was, you said that President Trump engendered a level of distrust. You said he made false statements to state legislators, to his supporters of all sorts, and somehow you discerned that his supporters were angry and that was somehow related to a criminal offense. I find that absolutely weak. I think it's misdirected. And
Time the gentleman's expired. Gentleman yields back.
All right, folks. You just watched it. The special counsel under oath, pinned down on the very foundation of the case against Donald Trump. And what did we get? Confirmation after confirmation that the conspiracy charge was deliberate, that the co-conspirators were identified, and that the line between protected political speech and criminal targeting of the electoral process was drawn clearly. This is the testimony sitting underneath the Supreme Court decision that just dropped a nuke on the Trump administration. Let's walk through it beat by beat so nobody can pretend they didn't hear what was said. It starts with the basics of conspiracy. The questioner asks Smith if a federal criminal conspiracy charge requires more than one individual. In other words, a contractual agreement with somebody other than yourself. Smith answers directly, that is correct. There has to be an agreement. No wiggle room. Then the follow-up. When you made the determination to charge President Trump with conspiracy, you surely knew that you as somebody else that he must have agreed with to engage in this act. Smith again. That's correct. We allege specific individuals in the indictment as co-conspirators. Let that sit with you. The special counsel did not invent a one-man conspiracy. He identified the other parties. He put their roles in the charging document. And yet the Trump orbit has spent years screaming that this was somehow a selective prosecution or a political hit job. Watch what happens next. The questioner presses. So you knew who you were going to charge when you pursued the indictment. You knew who the agreeing parties were, but you chose to list them as co-conspirators and didn't indict them. How often have you done that in the past? Smith responds that he has had a number of cases where he charged some members of a conspiracy and not others. Pressed further on how many times he charged one member and let everybody else off the hook, he says he's sure that's happened. It is not an uncommon thing to do in an investigation. This is the part that should make you furious if you've been listening to the endless claims that Trump was uniquely targeted. Selective charging of the principal while listing unindicted co-conspirators is standard investigative practice. Prosecutors do it when the evidence focuses on the leader who directed the scheme, when some participants are cooperating, when statutes of limitations or venue issues complicate charging everyone at once, or when the public interest is best served by focusing resources on the person at the top. Smith did not deny the existence of the other parties. He confirmed they were alleged. The outrage machine wants you to treat that as proof of bad faith. It is the opposite. It is proof the case was built around Trump's own agreements and direction. The questioner disputes it, of course, claims it's not common. But Smith holds the line. In his view, it is not uncommon. And then the questioning pivots to January 6th itself, trying to blur the distinction between ordinary political talk and the charged conduct. If a member of Congress moves to decertify a state's electors, that would not be a crime, would it? When you say to decertify, you make a motion to decertify on that January 6th that we do every 4 years. Smith answers, correct. And if another elected official urged someone to join them in that decertification, that's not a crime either, right? Smith, as you stated, It's not. Several members of Congress get together over breakfast. They say this is the normal path. We watched it because we saw the Democrats do it for every Republican president. That's not a crime to sit down at breakfast to talk about that. Or any other time together to talk about decertification, is it? Smith: No. It's not a crime to talk about that over breakfast. Hear that clearly. Talking is protected. Debating procedures is protected. Even pointing to past Democratic objections is protected. The special counsel is not criminalizing the speech of members of Congress who want to raise objections under the Electoral Count Act. He is not criminalizing breakfast strategy sessions. The Trump defenders love this exchange because it sounds like everything is fine. But keep listening. The line is not the talk. The line is the knowing use of false statements to target the lawful government function itself. The questioner brings up the deposition. You made the argument that an elected official who's been deemed to have lost could not knowingly make false statements about election fraud to target a lawful government operation. Isn't that true? That's what you said in your deposition, page 27. Smith confirms. I believe it's a lawful government function. Yes. An elected official who's been deemed to have lost could not knowingly make false statements about election fraud to target a lawful government function. That would be illegal. He does not deny the position. He apologizes only for trying to listen closely. This is the core. Protected speech includes saying you think you won. Smith agrees Trump was free to say that he thought he won the election. He was even free to say it falsely. That is correct. What he was not free to do was violate federal law and use knowingly false statements about election fraud to target a lawful government function. That is correct. And what is that function? The questioner presses. For you, that lawful government function is the certification process on January 6th, I suppose. Smith clarifies it is slightly broader. It is the collecting, counting, and certifying of the votes. The view of the evidence is that it begins from the point of time that the electors are certified through the counting of the votes. His recollection as pled in the indictment is from December 14th through the voting. The entire certification process from the state to the federal level. So the theory is not that Trump said mean things on Twitter. It is not that he held a rally. It is that after the electors were certified, through the counting process, he and the identified co-conspirators used knowing falsehoods about fraud to pressure, obstruct, and target that process. The breakfast talk is legal. The congressional motions are legal. The private belief that he won is legal. Crossing into coordinated, knowing false statements aimed at stopping or delaying the lawful counting and certification is where the criminal law kicks in. Smith did not filibuster his way out of it. He described the scope as pled. Then the questioner pivots to the broader claim. You've managed to filibuster right out of this thing, but your beef was that President Trump engendered a level of distrust. He made false statements to state legislators, to his supporters of all sorts, and somehow you discerned that his supporters were angry and that that was somehow related to a criminal offense. I find that absolutely weak. I think it's misdirected. Of course he finds it weak. That is the defense posture. But look at what the special counsel actually described. The case is not that supporters got angry in the abstract. It is that false statements about election fraud were knowingly deployed to target the specific government function of collecting, counting, and certifying the votes, beginning from the certification of electors. The anger of supporters is relevant when it is the foreseeable and intended result of those knowing falsehoods used as a tool to pressure the process. That is not somehow related. That is the mechanism. Calling it weak does not make the elements disappear. Smith already confirmed the elements under oath. Agreement with others, knowing false statements. Targeting of the lawful process from December forward. This is the testimony that now sits in the shadow of the Supreme Court decision the topic names. The nuke dropped on the Trump administration did not arrive in a vacuum. It arrived against a record in which the special counsel laid out the conspiracy structure, identified the other parties even while declining to charge them all at once, distinguished protected speech from criminal targeting, and tied the conduct to the concrete timeline of electors and certification. The questioner's attempts to expand every political conversation into the charged offense were shut down by the answers themselves. Talking over breakfast is fine. Using knowing lies to go after the counting of the votes is not. You want validation that the truth is being exposed? Here it is. The prosecutor did not hide the ball on the co-conspirators. He named them in the indictment as such. He did not pretend Trump could not claim victory. He said Trump could claim it even falsely. He drew the line at the knowing falsehoods aimed at the process itself. And when pressed on whether charging the leader while leaving others unindicted was unusual, he said it was not. The defense can call that weak all day. The record shows the opposite. A focused case on the person who sat at the center of the agreements and the statements. The Trump administration and its officials have spent years insisting this was all protected politics, all free speech. All Democrats did it too. The special counsel's answers under oath cut through that. Conspiracy requires the agreement. The agreement was alleged with specific people. The speech that stays protected is the opinion about who won. The speech that does not is the knowing false claim of fraud deployed to target the certification machinery from the moment the electors were set to the counting. That is the distinction the Supreme Court NUKE just reinforced by landing on the administration. There is no mystery left in these exchanges. The questioner tried to collapse the entire case into people talked about decertification and supporters got mad. Smith refused the collapse. He kept the focus on the knowing, targeted use of falsehoods against the lawful function. That is why the selective charging of the principle is not a bug. It is how these cases are often built when the evidence centers on the directing figure. You just watched the special counsel confirm the structure, the timeline, the distinction between talk and targeting, and the standard practice of charging the leader while listing the others. The outrage machine will keep spinning the unindicted co-conspirators line as if it proves the case was fake. It proves the opposite. They were alleged. The agreements were alleged. The knowing false statements aimed at the process were the point. And the Supreme Court just dropped its nuke on the administration that tried to treat all of that as ordinary politics. There you have it, folks. Let me know what you think in the comments.